Hi everyone, and welcome to this webinar on UK cross-border estate administration top tips and practical guidance. My name is Louise O'Toole and I'm a senior associate with Trowers and Hamlins. Just by way of very brief introduction, I started my career at Thomas Eggar in 2012, which later merged with Owen Mitchell. I was then based at Gately for around 4 years before moving to Trowers in 2023. I have around 10 years experience dealing with complex estate administration, and today I'm going to be focusing on cross-border estates. My main client base tends to be high net worth international clients, so we're talking non-UK clients with a UK interest, asset or connection, and I do have a particular interest and focus on the Middle East. So today we're going to look at top tips for dealing with cross-border estates from a UK perspective. And I'm going to incorporate some real-life case studies to demonstrate discussion points and put them into context for you. This is a really huge topic, and so we're going to be giving an overview today on some of the key UK concepts. We're going to look at UK tax residency in light of the changes introduced in April of this year, succession of assets, inheritance tax and capital gains tax, double taxation, how to obtain a UK grant, and then we're going to finish up with some compliance requirements. And I could probably talk for about an hour on each of these topics, so it's really going to be an overview, but you're more than welcome to get in touch afterwards if you have any questions. So from the 6th of April 2025, the concept of domicile as a connecting factor for inheritance tax purposes has been replaced with a residence-based system. And I'm going to cover that new system in more detail in the coming slides. But I wanted to make clear that domicile still plays a really crucial role in international estate administration, especially under double tax treaties, which rely on domicile to determine taxing rights and reliefs. So just taking one example, under the UK-US estate tax treaty, domicile is a key factor in determining which country has primary taxing rights in relation to a deceased estate. Domicile also remains important for succession, which we're also going to look at in more detail, in respect of deaths which occurred before the 6th of April 2025, or in respect of deaths to which the long-term residency transitional provisions apply. And again, we are going to touch on them just a bit later. So because domicile is still of key importance, I would like to just start with a brief reminder of the domicile regime. So to recap, before April 2025, statutory deemed domicile was relevant when looking at a person's exposure to UK taxation. This has now been replaced with the concept of a long-term resident. But essentially, from April 2017 to April 2025, a person was deemed UK domiciled if resident in the UK for 15 of the previous 20 tax years.